I would like to address on the growing concerns at the WTO level, especially in this digital era. I think the theme of the conference has been on actually the digital era. So I just wanted to give you an outline of what kind of concerns which the WTO is facing in this digital world. I don't know how many of you have got the trade law background, but for your simple understanding, let me tell you that the trade negotiations have changed their dynamics over the period of time. Because initial negotiations took place in 1940s. The GATT, General Agreement on Tariffs and Trade, was negotiated in 1940s. But then most other agreements under the WTO have been negotiated in 1980s and 1990s. The GATTs, TRIPS, or maybe actually any related agreement to the GATT, like sanitary and phytosanitary measures, technical barriers to the trade, anti-dumping, subsidies, safeguards, whatever agreements are there. Most of them are negotiated in 1980s and 1990s. Now, when the GATT was initially negotiated, there were not many extrinsic factors. The negotiators were primarily concerned about the trade. After the Second World War, they thought that unless and until they liberalized the trade, it would be a situation of the lose-lose for all the countries. There would be restrictions imposed by one country against other countries' products. Similarly, other countries also going to impose restrictions on the former country. So, which is a problem for everyone. So, for that purpose, they were focused in terms of the trade liberalization. And not many extrinsic factors were there. So, under the GATT, they had a full spirit of cooperation and liberalization, which is evident in the fact that almost all obligations under the GATT are general obligations. Like, say, once a state becomes party to the GATT, it has to actually follow the MFN treatment, it has to follow the national treatment obligation, then bindingness in terms of the tariffs, right? Customs duties, once they have bound the customs duties, they have to follow that. Transparency requirements, prohibition on quantitative restrictions, so on and so forth. There are multiple obligations which have been incorporated under the GATT, which are all general obligations. And once the state becomes party to the GATT, they have to follow them. But then, as the time passed on, and when you come to 1980s or 1990s, there were so many extrinsic factors which have also started to influence the negotiation. Like aspect of environment, aspects with respect to the, of course, I think the next presentation itself is on the environmental issues or product PPP based restrictions and all actually that you will, discuss right after my presentation. And even issues with respect to the labor rights, public health, so on and so forth. There are different extrinsic factors which started to actually come into the forefront. And trade was not something isolated, rather, actually, it was to be looked from the perspective of all those extrinsic factors as well. And that is why when the negotiation for GATS, General Agreement on Trade in Services, or maybe the TRIPS negotiations happened in 1980s and 90s, you find that the dynamics have completely changed. The same high level of cooperation and then elimination of the restrictions was not found under the GATS and the TRIPS. States were reluctant. They were skeptical about taking such a kind of a vibrant obligation on them under the GATS and the TRIPS. For a simple example, under the GATS, General Agreement on Trade in Services, you don't have all obligations as the general obligations. You have two parts in it. Part 2 basically speaks about the general obligations. Part 3 speaks about the specific commitments. Right? While MFN treatment, publication of the measures, domestic regulation, enforcement, administration, or maybe say mutual recognition agreement, all these things are mentioned under the part 2 as the general obligations. Market access and national treatment are mentioned under part 3 of the GATS. They are the specific commitments. Specific commitments in the sense, states would not be obligated to grant the market access or the national treatment soon after they become parties to the GATS. They have to make commitments subsequently and sector specific, right? In a particular sector, like say, for example, in telecommunication services, if the state want to grant the market access, only it can grant. Or educational services, foreign educational services being rendered in India, right? If government of India is willing to allow that, then only it can allow the market access under Article 16. Similarly, national treatment, whether the equal treatment would be given to the foreign service supplier in our country, like that of our domestic service supplier, that is also left to the state under Part 3. So, unlike under the GATT, under the GATS, market access and national treatment are not general obligations. Any state which would like to prevent the market access in any sector of services can very well do that without taking any commitment under Part 3. Right? And even they can discriminate also the foreign service suppliers or foreign services from that of the domestic services or the service suppliers by not giving the national treatment under Article 17. So that's why under the GATS, you don't find such a kind of a higher level of commitment like the GATT. Similarly, under TRIPS, countries have agreed only for a minimum requirement. I think all of you must be aware of the fact that TRIPS is not actually laying down a equal standard of the IPR protection. Rather, it is only mentioning about the minimum protection. Over and above that, anything is possible. So, therefore, it is not a specific obligation or a commitment which has been undertaken under the TRIPS. So, dynamics have changed a lot over the period of time in terms of the trade negotiation. Every time the states have thought in terms of protecting their own self-interest, they want to protect their domestic industry, domestic service suppliers, so on and so forth. And more extensive factors influence started to happen in 1980s and 1990s. As I said, environmental aspects, labor rights, so on and so forth. So many things have come up actually. And question was, should they be considered in the WTO negotiation, in the regime, what has been established? Is there a requirement of considering them? Next slide, please. Next slide, please. Right. One of those extrinsic considerations has been in terms of technological development. You can find that there is a boom in the digital trade now. Right? Everything is available online. You have so many online platforms, maybe Amazon, Flipkart, Alibaba, or whatever different kind of actually the online platforms available with respect to the providing the products, services, etc., etc. This digital boom in the digital trade has got an intersection amongst all different aspects. Like say, for example, it has the influence on the products, trade in products, right? You can order anything online, you can get the product. It has an influence on the services, right? So a lot of services can be rendered online now. Like say, for example, medical consultancy services, legal consultancy services, or even repair of certain equipment. Even the services can be rendered online with the help of the digital platforms. It has also got implication on the IPR, right? So protection of the trademarks in different jurisdiction, protection of patents in different jurisdiction have all become the issues in the wake of the digital the trade. Now, there are many countries, especially the developed countries, who are actually arguing for a separate negotiation with respect to the liberalization of trade in e-commerce or the digital trade. Right? They want actually more and more liberalization. Restrictions need to be reduced down in terms of the digital trade. And even they had a controversy with respect to the customs duty. You must have heard about the moratorium and all actually. Right? Whatever it may be, so they are all thinking in terms of going for more and more liberalization with respect to the e-commerce. One of the questions which has cropped up in terms of the e-commerce negotiation has been, is there a requirement of considering the digital divide? Because all the countries in the world are not having equal footing in terms of the development of technology. You have the developed countries who are having the faster internet connectivity, wherein you have the developing or less developed countries having the slow internet connectivity, or some of them not even having proper access. Right? So that's a digital divide. Some countries are having all facilities, some countries are having no facilities at all. So countries who are having those facilities are having an added advantage in terms of the digital trade. So the question is whether this digital divide between the developed countries and the less developed countries, whether it has to be considered for the purpose of ensuring that there is a fair negotiation. That has been the debate. Developed countries have always argued, why should you consider this? This is just a failure of a developing or a less developed country to develop themselves. So simply because the less developed the countries are failing in terms of the technological development, is there a necessity of preventing the developed countries trader from taking an advantage? You cannot do that. That's the kind of an argument which the developed countries are arguing. But on a contrary note, developing countries say that your negotiation is not a fair negotiation. What are you doing? Because you are at a different level playing field. When there is a different level playing field, you are supposed to give more concession to the countries which are at a lower level of, that bargaining power, right? And the developed countries have to, in a way, actually cooperate in terms of that. So therefore, less developed countries are saying that consider that digital divide and provide us a more favorable treatment, right? And then maybe there can be actually the a kind of a negotiation and a treaty can be entered into with respect to the e-commerce. Next slide, please. Right. Now, this debate with respect to the negotiation has been for a long period of time. WTO ministerial conferences, multiple ministerial conferences addressed it. But finally, in 2017, in the 11th ministerial conference at Buenos Aires, right, that was the final, actually, the discussion with respect to the agreement on the e-commerce. But there was no consensus. All states were not agreeable for a particular the agreement. So finally, 71 countries, they came up with an initiative which is called as Joint Statement Initiative of 2017. Joint Statement Initiative on the e-commerce. They said that anyhow, if there is no consensus, if all countries are not agreeing, we will go forward. We will establish actually a particular regime. That's how they went forward, right? Primarily consisting of developed the countries. Though Asia and Africa were opposing, most of the countries in Asia and Africa were opposing for such kind of the system because there is an uneven level playing field. So therefore, they were opposing that. Despite that, these 71 countries went ahead with the joint statement initiative. And over the period of time, they also developed the draft of an agreement. This year itself, 26th of July 2024, they came up with an agreed text with respect to the e-commerce, liberalization of the e-commerce, a kind of an agreement, draft agreement actually they have come up. 91 countries have joined now. However, countries like India and South Africa have consistently opposed it. Right, and even our neighboring countries also, Pakistan, Bangladesh, right? So in Asia also multiple countries, Africa also multiple countries have not become part of this. Next slide, please. Now this agreed text or maybe the concerned agreement draft brings forward the question: where is the inclusiveness? WTO has been known for its inclusiveness. If you look into the GATT, there is a separate part on the trade and development. Developing countries or less developed countries are giving preferential treatment, ensure that their voices are also heard. But here is a situation wherein initially 71 countries and now 91 countries are thinking in terms of a regime amongst themselves. So, is it that inclusiveness is losing its significance in the WTO? One of the major issues. Added to that, if you look into actually this e-commerce negotiation, there was no mandate of the WTO. Usually, in the previous, of course, previously also certain plurilateral agreements have been entered into. There is a distinction between multilateral and plurilateral. Multilateral, almost all the countries together having an agreement. Plurilateral is only certain countries coming together and having their agreement. Previously, also WTO had the plurilateral agreements. However, those plurilateral agreements have been entered after the mandate given by the Ministerial Conference or the General Council. The WTO General Council or the Ministerial Conference have said that, okay, negotiation can go on plurilaterally with respect to the particular aspect. But here, negotiation has taken place without any such kind of a mandate by the WTO. Ministerial Conference or maybe the General Council have not given any kind of such a direction in terms of the negotiation. That's why the legality of this agreed text itself is debated by most countries, including India and South Africa. Next slide, please. I can draw the parallel also with the current WTO dispute settlement mechanism as well. Right? A similar kind of a concern is also there in the WTO dispute settlement mechanism. Most of you might be aware of the fact that appellate body of the WTO is not functional at present. Right? The WTO used to have a panel and then appeal to the appellate body. Appellate body is not functional because the United States has unilaterally stopped the appointment of members to the appellate body. Since 2019, AB is not functioning. In the absence of the appellate body, European Union has come up with the MPIA, multi-party interim arbitration agreement. So they went into an arbitration procedure wherein an appeal can be made to the arbitrator, an interim arrangement until the appellate body debacle is settled. That's what they basically say. But again, this was not with the mandate of the ministerial conference, not with the mandate of general council, and only 52 countries are part of it with the opposition of majority of the other countries. So that's why what I find is that this inclusiveness is losing significance in the WTO, which is one of the major problems. And even in terms of the e-commerce negotiation or the digital trade negotiation, we have to think in terms of bringing back that inclusiveness and then have the comprehensive regime with respect to the multilateral aspects. So that's what is primary thing, and definitely the WTO has got a big concern. And of late, even the consensus or acceptance by all the countries has also become a big problem at the WTO. So I believe that this the the digital era is posing more challenges to the WTO by virtue of this. So that's all. Thank you so much.